Hello and welcome to session 2 of the second annual Completed Life Fall Conference. My name is Sarah Kiskadden-Bechtel and I am the Program Director for the Completed Life Initiative, and I will be your host today. At the Completed Life Initiative, we promote self-determination and dignity at the end of life. If you are new to our event programming, please feel free to explore our video archives on our website after today's event at www.completedlife.org. Our second annual conference examines core elements of medical aid in dying. What happens after legalization of assisted dying? How has the legislative landscape in the United States shifted over the past 30 years? And where is it headed? What is the global significance of the Right to Die movement? Whether you are new to our Completed Life community or a returning attendee, we invite you to attend each of our 4 conference sessions and come prepared to ask lots of questions. These sessions are invaluable learning tools meant to empower you to have an informed conversation for yourself and with your loved ones about the question, what does it mean to live a completed life? Today's session 2 will provide a narrative overview of major right to die legal cases in the United States as a historic and legal roadmap of where we've been as we evaluate the future of the movement. Looking back at these major legal decisions, our speakers will explore the historic challenges faced by efforts to establish a right to die. Our esteemed panelists, Dr. Timothy Quill and Professor Thaddeus Mason Pope will explore which decisions advocates have had to accept and which were unsuccessful attempts at passing aid in dying, which restrictions were imposed, for example, framing the discussion in terms of, quote, assisted suicide, end quote, compared to, quote, assisted dying, end quote, and how to see these decisions modified and whether and how these decisions are too restrictive. A little background on our speakers. Dr. Timothy E. Quill, MD, is the Distinguished Professor Emeritus of Palliative Care and Professor of Medicine, Psychiatry, Medical Humanities, and Nursing at the University of Rochester School of Medicine, URMC. He was the founding director of the URMC Palliative Care Program, and Dr. Quill has published and lectured widely about various aspects of the doctor-patient relationship, with special focus on end-of-life decision-making, including delivering bad news, non-abandonment, discussing palliative care earlier, and exploring last resort options. We are also very lucky to have Dr. Tim Quill as the Completed Life Initiative's clinical advisor. Welcome, Tim. Thaddeus Mason Pope, JD, PhD, HECC, is a key advisor to the Completed Life Initiative, adding expert insight and counsel on voluntarily stopping eating and drinking, also known as VSED, and medical aid in dying. Mr. Pope is a foremost expert on medical law and clinical ethics. He maintains a special focus on patient rights and healthcare decision-making. While he serves in a range of consulting capacities, Mr. Pope has been particularly influential through his extensive high-impact scholarship. Ranked among the top 20 most cited health law scholars in the United States, Mr. Pope has over 220 publications in leading medical journals, bioethics journals, and law reviews. He co-authors the definitive treatise, The Right to Die, The Law of End-of-Life Decision-Making, and he runs the medical futility blog, which happens to have over 4 million page views. And Mr. Pope is also an esteemed member of the Completed Life Advisory Board, and we are so grateful to have him here today. So welcome, Professor Pope. Before we begin, please be aware that you may input your questions into the chat feature located on the lower right-hand corner of your screen. Please feel free to submit your questions throughout today's event, and we will pause periodically to answer your questions as well. And we will also turn after the presentations to your questions for an interactive Q&A with our esteemed panelists. We welcome your questions at any time. In addition to the chat feature on the lower right-hand corner of your screen, there's also a Q&A feature. So feel free to put in questions in either location. If you'd like assistance with closed captioning today, you may toggle on the box located in the lower left-hand corner of your screen that provides captioning for the spoken words of our event today. And throughout today's event, feel free to tag us in your social media posts and tweets at Completed Life and hashtag Completed Life. And finally, the recording of today's event will be published after the conference concludes. So without further ado, Dr. Quill, please take us away.
Thank you, Sarah. And it's a pleasure to be with you all, be with both you and Thad, as well as our group today. And look forward to having a good interaction around some of the challenges we face in end-of-life care and options for people. So I'm gonna dive right in. Sarah's going to be toggling the slides, so I'm going to be taking mainly a clinical view, and I'm going to leave Thad the legal part of this. Although I may scratch the legal parts of it, it'll be limited because it'll be from a clinician's point of view. But there is a lot of interface in this zone between clinical and legal activity. Next slide. So I have no significant financial conflicts of interest. I have been an advocate for allowing increased options for assisted dying at the end of life as a last resort. So I have a point of view on this subject. I've written a lot about it from a clinical point of view, and that's where I come from. Next slide. So this is a picture of Dr. George Engel, who was one of my mentors growing up. He was the founder or one of the big describers of the biopsychosocial model. And we've expanded that biopsychosocial spiritual model, but it is a way of viewing complex problems and trying to help people find solutions that might fit for their situation. And this is just a picture, a graphic of the model, and you can see how you could move from cultural to family to person-centered interventions to nervous system down to very basic biology. And in palliative care and medical care, we move up and down this scheme regularly, trying to find things that will help people live better, perhaps live longer. This is one of my other mentors, Art Schmally, who was a psychiatrist and an internist, and he applied a lot of the biopsychosocial principles to end-of-life care. So it is really a place where utilizing all of that dimensional interventions can really help maintain quality of life and help people die in a way that makes sense to them. Next slide. And this is a picture of Elizabeth Kubler-Ross. If this talk was being given in Canada, I might use Dame Cicely Saunders, but she was, I consider her the mother of the hospice movement in the United States. She really learned a lot from taking care of people who were dying and applied medical principles to doing that, and really tried to awaken us to the fact that there might be some amazing things that occur at the end of life, and that we should try to make that happen more often and more humanely than perhaps we were at the time. This is Nancy Cruzan, and this is a picture of her. She's one of the many end-of-life cases that have been going on. She was in a persistent vegetative state and was trying to, her parents hoped that she would get better for a period of time, which she did not. And then they had to try to figure out what to do next. Next slide. And this is a picture of her parents who were struggling to make sense out of all of this and trying to figure out whether to keep going, whether to stop. And these were just among the many initial early cases with regard to end-of-life care that we were all struggling with in those days. So Karen Ann Quinlan, Nancy Cruzan were really pivotal in making us really think through what can medicine, what should we do, what can we do, how can we do this better. And Thad's going to cover these cases a lot more detail as we go forward. So again, one of the things that was happening as I was going through training is we were able to keep people alive longer. It was really, medicine was starting to have some real effect. And that was generally a very good thing, but there were also times in which we started treatments that we hope people will get better. We put people on ventilators hoping they'd get off, but some people ended up staying on them. And then we had a whole new set of questions. Do we take people off ventilators once they've been on? Who makes that decision? How long do you try before you make that decision? Is it permissible to do that? And we were really just flying blind initially in this zone. And of course, in those days, and perhaps these days as well, you don't have a right to health care in this country, but you will get CPR at the very end of your life unless you specifically say you don't want it. So we really have this very last ditch effort to pull people back from the edges of death. Generally a good thing if people are dying in a sudden way, but if applied to people who are dying in a slow and prolonged way, maybe not the right thing to do. Way too much technology, way too invasive, and not likely to work at all. And then we had at the same time the hospice movement beginning to happen, and we learned that we could that there were amazing things that could happen in people's lives toward the end of life if we could accept that they were dying. Maybe we would keep them at home instead of at the hospital. Maybe we would devote our energies, instead of trying to treat their underlying disease, to keeping them more comfortable and helping them make the most of the time they have left. And there were some real luminaries who helped us figure this all out. Elizabeth Kubler-Ross being one of them, who really brought out that there might be stages of dying. There might be things that can happen, developmental things that can occur, and maybe the stages weren't quite as rigid as we initially thought, but they really were important pieces of the puzzle. And some of it is very mundane. So a lot of times it's not a lot of deep death talk, or maybe some people don't want to talk about it at all, but they might still savor the time that they spend with their family. Maybe it's playing cards. Maybe there's not a lot of explicit conversation, but this is really important time in a person's life, and we ought to learn how to make the most of it. And again, hospice has really helped us figure that out much better than we ever did in the past. There's this opportunity for human contact. Maybe kids don't have to be as afraid of being around sick people. Maybe they can be a part of that process, and they then won't be as fearful when they face illness and sickness in their own lives, potentially way down the road, because they've had experience caring for others within their own world. Next slide. There is a technical part of this work. So if you're going to take care of somebody at the end of life, you better know how to manage pain. And it's not just pain, it's also shortness of breath, and it might be delirium. And this takes a lot of medical expertise that we have started really teaching all good doctors who are taking care of sick people. And then maybe the hospice doctors or palliative care doctors take care of the tougher cases. But we all have to learn how to do this, because this is a place that all of our patients will go eventually if we care for them long enough. So when we use medicine's powers to help people die in a very peaceful way, we are doing a wonderful thing. And again, we've, I think, gradually come to grips with this, and death can be a beautiful process and meaningful for all those involved, and it doesn't have to be something to be as terrified about as perhaps we were for a while. But if we are going to care for people at the end of life, we better be ready to manage some of the tougher things. So this man might have had lung cancer or emphysema. He may have fought against his disease for a long time. He may not want to go on a ventilator. But when he shows up in the emergency room, we better know how to manage shortness of breath and help him get through this. And getting through this may be that he's actively dying. So we're going to have to be a little more bold. We may have to give larger doses to help them escape the kind of severe suffering that is possible. And this has been a real challenge for our medical systems. Now, others have begun to weigh in a little on this. So this is a book called Final Exit that was written by Derek Hemfrey. And he thought about, well, if people are dying, maybe we should give them some choices in this process. Maybe they should have the option of what he called self-deliverance, which meant potentially taking an overdose of medication to escape the late phases of this process. And again, this led to a really wide-ranging conversation about doctors must not kill patients on the one side, and doctors must be much more committed to easing the suffering of suffering patients on the other. So this has led to a big debate that's still going on today. And this is Elizabeth Bouvier, again, being kept alive by a feeding tube. And again, challenge about, do we keep going with the feeding tube? Do we stop? Can we care for people indefinitely on feeding tubes? There are all kinds of questions that are still being struggled through in our systems today. Next slide. And Betty Rollin talked about assisting the death of her mother, and again wrote a book about this, and really just started all of these possibilities were being brought out of the closet in thinking about trying to provide people with better and more options at the end of life. The AMA has weighed in very heavily on this, mainly on the negative side, saying doctors must not kill patients. They've been very hesitant about getting people involved in easing the suffering of dying patients. So they've struggled with this as an organization. And that's been one of the tensions involved in this whole process of trying to develop options for people at the end of life. And again, I think this is a picture of Nancy Cruzan. Is Nancy Cruzan, Thad? Not if it is.
Yeah.
Yeah. So again, she was in a persistent vegetative state, and her parents hoped that she would get better for a long period of time, and then accepted the fact that she was not going to get better. Next slide. And then they went through a very long process of trying to figure out, what do you do when you stop in these circumstances? Can you ease the suffering of dying patients? And again, there are a lot of people weighing in on this, on the pro and negative side, and this led to a real cultural conversation about what kind of options should we provide for people at the end of life. And of course, we had these are two of the wild cards involved in this process. Jack Kevorkian, who was saying, if doctors are not going to help patients in this circumstance, I will. And he was sort of assisting in the suicide of large numbers of people over time, some of whom were terminally ill, others of whom were not. Barbara Walters, was in the media, and the media was all over these kinds of dilemmas. So this was really front page news on a repeated basis. And this is where I had this experience that put me kind of in the center of this debate for a while. This is a picture of a patient of mine who I'll call Diane. And she was a primary care patient of mine. She developed myelomonocytic leukemia. And this was a disease that might have been treatment that might have helped a little bit, but it was very invasive treatment. And she wanted no part of that treatment. And I actually at the time found that very difficult, because, I had taken care of her for a long time, and thought that maybe this could really help her. But she was also very aware of the side effects of the treatments. And this was really very aggressive treatment that included aggressive chemotherapy, bone marrow transplantation, and so forth. And she wanted no part of that. And then she pushed the conversation further, and that she said, because then I offered her hospice care, which she said, great. And she appreciated that. But she also said, you know, if things get rough toward the end of hospice, I want to skip the last part of that. And of course, she was the first person that really asked that question directly of me as I was going through. And I certainly struggled with that. I talked to a lot of people who I knew who had worked in hospice and palliative care, and it turns out a lot of people had faced a patient or two in their careers and decided how to help them, often surreptitiously, by easing their suffering, by providing medication that they could take as an overdose. So Diane and I developed a pact that I would provide her with that medication, but she would meet with me before she would take it to make sure she had looked at all the other options. Next slide. This is just a picture of her leukemia. Again, the leukemia she had was a particularly aggressive leukemia for which there were not very good options at the time. Next slide. And this is a picture of her later on in hospice. So she actually had a very good experience on hospice. She had the option of taking her life at the very end if once she and I had agreed that it was at the very end. But during the phase that she was on hospice, she actually took several forms of life-prolonging therapy, mainly antibiotics that treated her because she didn't have the ability to fight off infections. So we worked together, and eventually, however, she did reach a point where she was having intractable infections, shaking chills, met with me a final time, and I did provide her with medication that she then did take as an overdose. Next slide. And at the same time this is going on, there was a lot of discussion going on in medicine about what are doctors' responsibilities toward hopelessly ill patients, patients who are not going to get better. So this just shows the evolution of this thought that was occurring at the same time. On the one hand, there was a lot of talk about doctors must not assist patients in dying, kill patients, as it was phrased. And then later on, that there was a rethinking. Maybe we do have some more responsibility to people who are suffering at the very end of life to perhaps ease their dying. And so this was a very active discussion at the time. Next slide. So I had gotten, after Diane had died, I had talked to a lot of colleagues of mine, and we had I had talked about, well, maybe I should write this up because, you know, I was a pretty respected palliative care doctor. I was much more difficult to dismiss than a Dr. Kevorkian, for example. And so I decided that I would write this up, wrote it up as a narrative, and I sent it to the New England Journal of Medicine. Of course, at that time I had never had anything published in the New England Journal of Medicine, but I got a phone call from Marcia Angel, who was then the editor of the New England Journal of Medicine. And she asked me basically, are you sure you know what you're getting into? Are you sure you really want to publish this? But Marcia, it turns out, had a very strong view about this subject. She had taken care of her husband, who was also an editor of the New England Journal, who had some serious suffering toward the end of his life, and she really thought that this possibility of having an escape at the end of life should be made available to people who choose to want to make it. So she was an open supporter of this idea. And this next slide. This led to them publishing my narrative about helping Diane to die, which was just a description of this whole process. Next slide. And this led, I did get some legal consultation before I did this, and I was told that I would never be successfully prosecuted. Which was true. But what I wasn't fully prepared for was what you can go through on your way to not being successfully prosecuted. So there was a bit of a firestorm around the publication of this. This is the New York Times on the day after I published it. And I was being interviewed all over the place. And next slide. The local prosecutor wanted to talk to me because if I was so sure that I didn't do anything wrong, why wouldn't I talk to him? I did get some legal consultation, which mainly what they told me to do was to stop talking for a while, which I did do. But eventually, they eventually said this will probably go to a grand jury hearing. And at that time, I waived my Fifth Amendment rights and went and testified before the grand jury. Grand jury seemed to fully understand actually the what was going on. They asked me if I was there because of what I did or because of what I wrote. And the grand jury eventually chose not to prosecute me. Next slide. So I was cleared. Next slide after that. There was also the New York State could have disciplined me. They could have threatened my license in this regard, but they chose not to do that. And again, understood that this was about generating a conversation about this issue, which it did do. Next slide. So at the same time, Oregon was passing a law that was openly allowing this option as a last resort. Next slide. And eventually, Thad will talk about this more, but we challenged the law in New York State. I got some very smart lawyers to help craft a case, which eventually was heard by the U.S. Supreme Court. And again, Thad will cover this later on. So some of the these are just some of the quotes from the Supreme Court decision. This is an issue that every one of us faces. It's a question that raises a basic question about who decides. Timing is a legitimate factor. Maybe we should wait till we know more. And not aware of any doctor ever being convicted for pursuing this. So this was some of the conversation during the Supreme Court decision. Next slide. This is a question of ethics, morals, resources, and our commitment to treat the elderly and the infirm. What worries me most that 1 to 2% need die in pain, but about 25% or more do die in pain. And then you're going to have factions fighting this out in every session of the legislature. How far can we go in regulating this? And then finally, Scalia said, why is this limited to those on the threshold of death? We are all terminal. So again, can you go back one, Sarah? So we lost 9-0 at the Supreme Court, but there was some language that they used that really opened the door for further discussion and exploration, which Thad will talk about later on. Next slide. So since that time, we have developed what I call last resort options. So the options that people have at the very end of life are much more broad than they were. And these are a list of 6 options in rough order: societal acceptance of permissibility. So again, if you have pain or shortness of breath, accelerating opioids are widely accepted, even to the point of unconsciousness if needed. Stopping or not starting life-sustaining therapy, generally widely accepted that is permissible, even if your desire is to die sooner. And then there's 2 what I call gray area options: the voluntarily stopping eating and drinking, which we have developed a book on recently, and then palliative sedation, potentially to unconsciousness for addressing more severe kinds of suffering. And then in the red area, physician-assisted death, or also called physician-assisted suicide, where the clinician provides medication for overdose that a patient takes by his or her own hand. And then voluntary active euthanasia, where the doctor not only provides the medication, but delivers it him or herself. Next slide. So there are needs for safeguards for virtually all of these last resort options, and the safeguards are fairly familiar and common. To protect the vulnerable from error, abuse, and coercion. I want to make sure people are getting adequate palliative care. The risks cited for assisted dying are also relevant for the other last resort options, and any kind of safeguards must balance flexibility and accountability, privacy and oversight. Next slide. The categories: generally palliative care, because that's the standard of care to address suffering. It needs to be accessible and found to be ineffective. There needs to be rigorous informed consent for any of these last resort options. We have to be as clear as we can be about the diagnosis and prognosis. And ideally, there's going to be a second opinion by people who are experienced in caring for that particular disease. And then that we document and review and study what the practice is. There is a risk of don't ask, don't tell, which is sort of the old approach to this. It means that access is going to be very uneven and unpredictable. It encourages people to have unclear conversations. Don't take too much of this or it might kill you. What is the doctor really saying with that? So there's risk of misunderstanding. And there's no safeguards when don't ask, don't tell to ensure that people are getting adequate palliative care and that they've been fully evaluated. And then families are left with bereavement problems because of secrecy. So if we don't ask, don't tell, and families are not really going to be able to talk about it or work through their feelings about it, which is an important part of the grieving process. There are risks to being explicit about last resort options. Some patients and families are going to be frightened by the availability, about the possibility of these options. Some people might prematurely choose death due to family pressure or financial pressure. It could theoretically undermine progress in hospice and palliative care. Maybe clinicians will be less committed to address difficult suffering and might provide an easy out as suffering increases. And it could undermine fundamental physician values. And there's a lot of debate going on around these questions between people who are in favor and those who are opposed to this practice. So the bottom line for palliative care should be part of the treatment plan for all seriously ill patients. It shouldn't be waited until people have a drastic need. All clinicians are going to care for really sick patients, should know how to do the basics of palliative care, and then on the tougher cases, get specialist palliative care backup. And again, we are all trying to use medicine's potential in a very individualized way. So that's our challenge. Next slide. Hospice care is the premier program for providing palliative care for now terminally ill patients, but it's a very hard transition for many patients and families. Yet most are very appreciative once that transition is made. You get more help at home than any other home care program in the United States, and it can also be provided in nursing homes and hospice houses. And most people can find meaningful and relatively peaceful death on hospice, but there's still many challenges. Next slide. The last resort options, bottom line, they're only sensible in the context of excellent palliative care. Currently, the options are very unevenly and unpredictably available. In my opinion, all options should be subject to similar safeguards, and open processes are much safer, more predictable, and accountable than secret processes. So here's some references that'll be available, and I'll stop at that point, and I don't know whether we're going to take a couple of questions or keep going, Sarah.
Thank you so much, Dr. Quill. I'm happy to take brief questions specifically about Dr. Quill's presentation before turning to Professor Pope. So let me just open the chat. Give me one moment. Someone in our audience is wondering, Dr. Quill, what year did you care for the patient named Diane?
It was 1990. The article was published in 1991, but I cared for her in 1990.
Thank you. Jocelyn is wondering, one issue mentioned at the previous session, access to information about aid in dying from a provider who works for a religious healthcare system. Are there any states that require all providers to at least provide a referral to another entity that would provide medical aid in dying? Your thoughts?
Let Thad answer. Yeah.
I'll jump on in. So first of all, every state that's legalized medical aid in dying permits opt-outs, right? So no clinician needs to participate if they don't want to. No entity needs to participate if it doesn't want to. Nevertheless, despite that opt-out, right, we are balancing the clinician's right to not be complicit in something they consider immoral. We're balancing that against the patient's right to access a legal, socially accepted end-of-life option. And so the way that that balance gets struck is that we do impose some duties on the objecting provider. The one thing they always have to do in every state is transfer the medical records. So when the patient then goes and finds a new provider who is willing to participate in medical aid in dying, the current objecting provider must transfer the records. In Vermont, they have to do a little bit more than that. So they will have to tell the patient that there is this option and let them know here's a place or here's a provider from which you can learn about that option. I might because I object. I don't want to talk to you about it, but here's a place where you can learn more. And interestingly, just a few weeks ago, California amended its End of Life Option Act to basically further protect patients from conscience-based objections. So, among other things, the new law, effective in January, requires objecting facilities, hospitals, hospices, other, to post their policies. So you would know up front whether or not the facility from which you're getting care is or is not going to participate.
Thank you, Thaddeus. Kathy's wondering, along those lines, can physicians prescribe aid in dying even if their place of employment does not support aid in dying?
Well, that's actually being litigated right now. So as an example, Colorado specifically says in the statute that if you are off the clock, off the premises, right? So you might work for a Catholic affiliated system like Centura in Colorado, but if you are on your own time in your own clinic that you operate somewhere else, then you may participate in medical aid in dying. That's what the statute says. But what Centura is arguing, and this is still being litigated, what Centura argues is that they have a constitutional right as an organization to uphold their religious values, and that would include prohibiting all their employed clinicians or otherwise affiliated clinicians from participating, even when they're off the premises. And so that's actually being contested right now, which is what exactly is the scope of a clinician that wants to participate, but they work for an entity that doesn't want to participate. The laws say that that's okay, but it is being contested in the courts right now.
Thank you. And one last question before we turn to Thaddeus's presentation. Gary is wondering, what about people facing dementia who become incompetent to defend their wishes? How do we support those individuals at the end of their life?
Yeah, this is a huge challenge. I think there is some work being done about whether you could do a dementia directive that might empower clinicians to act on your behalf after capacity has been lost. I think that would be very, controversial and cutting edge, but it's possible. And I think if that's what somebody wanted, it's a good idea to put it out there in play, even though it may not be able to be acted upon. I think what our fallback position would be absolutely purely comfort measures only, so that there's no treatment to prolong life. There's no desire or need to provide adequate nutrition and hydration. It's purely comfort. And so at what might even be called minimal comfort feeding only, because we know of a person's desire to shorten this process as much as possible. So then we provide the minimum amount that provides enjoyment. but no desire to keep nutrition up and to measure that. And then if there are events that occur, manage them very aggressively with comfort. So no antibiotics, no fluids, none of those kinds of treatments.
I'll just add that if you can't qualify for medical aid in dying in the United States, so just focusing on medical aid in dying solely on the basis of a dementia diagnosis, because you have to be both terminally ill within 6 months of death and have decision-making capacity. And the long progressive nature of dementia would make it impossible to satisfy both of those eligibility conditions at the same time. Canada has opened up a little bit of space for dementia for medical aid in dying, but at least right now in the United States, that's not one of your options. The ones that Tim described are, but not medical aid in dying.
I think that voluntarily stopping eating and drinking while you still have capacity is probably the only realistic option in the United States. And again, then the timing is really key. You want to put it off as long as you can, but if you put it off too long, then you lose capacity, and so it's not going to be able to be done.
Well, thank you both. And now I'd like to turn to Thaddeus for his presentation. Oh, Thaddeus,
I'm going
you're
to
muted.
share my.
Excellent.
Okay. Does that work?
Yes, very much.
Okay.
Thank you.
So I'm going to talk about basically the history and the future of medical aid in dying. And I'm going to do that in contrast to Tim, primarily from a legal perspective. So here's the roadmap for what's coming up in the next 20 minutes. And it basically is going to come in three parts. First, I'm going to explain why we actually need to affirmatively legalize medical aid in dying, the paths that we've taken to do that, to affirmatively legalize medical aid in dying. And then third, to describe some different current efforts to expand access to medical aid in dying. So to start with this is a starting point. Criminal laws in every state criminalize what they call assisted suicide. And I think this is an important starting point because since the 1800s, across the entire country, one person helping somebody else commit suicide is a crime. As former Justice Scalia observed, assisted suicide prohibitions are deeply rooted in our nation's history. So just to take New Mexico as an example, right? They give the same statute in every state. Assisting suicide or aiding another in the taking of his own life is a felony. So that's an obstacle, right, to just doing medical aid in dying. As Tim described, he ran into in New York. Now, if we flash back to 1976, assisted suicide laws were an obstacle to even other right to die rights. So during the 1950s and the 1960s, we developed a lot of ICU technology like mechanical ventilation and dialysis and feeding tubes. And that then raised the question, well, can we turn these things off, right? We can access them. They're available technologically, but what if we don't want them? So that really is what started the right to die movement. It really started in significant part, as Tim described, with the Quinlan case in 1976. And then later with Cruzan, and it's worth noting there was at least 100 other appellate cases from coast to coast and everywhere in between. And basically they all held that everyone has a right to refuse treatment, even if that treatment is life-sustaining. But there was, back in the early 80s, there was this question, which is, well, wait a minute, when we turn off a ventilator, stop dialysis, disconnect the feeding tube, is that assisted suicide, right? Because it looks like we're taking an act that is causing the death of another person. It looks like assisted suicide. So people were a little worried about that. So there was what you might call a chill from those assisted suicide laws, which were on the books. They still are on the books. So what did we do? We just wrote right into, each state did this, into what's called its Healthcare Decisions Act, that death resulting from withholding or withdrawing treatment does not constitute suicide. Just to clarify and give everybody some comfort that when you withhold or withdraw, that's not assisting a suicide. We don't have that with medical aid in dying, except in the states that we'll get to. Because as of right now, in New York, for example, medical aid in dying is assisted suicide. And New York defines assisted suicide as a felony, therefore MAID is a felony, right? It was back when Tim's case, and it still is today. Therefore, what you need to do in New York, for example, is you need to affirmatively exclude MAID from the scope of the criminal assisted suicide prohibition, right? To clarify that aid in dying is one thing and assisted suicide is something else. And what I want to describe are the paths that we've taken or tried to take to separate those two things and keep aid in dying outside the scope of criminal assisted suicide. So as Tim described, one path that he took personally, was to litigate to try to say that there's a right under the U.S. Constitution, right? And there were actually several different cases, and they argued that there's a right under the Due Process Clause, there's a right under the Equal Protection Clause, there's a right under the First Amendment. Some of that really early cases actually were brought by Jack Kevorkian, but things actually really got underway in a more serious way in New York with Tim. At the same time, there was basically another case that started in Washington with this physician and also some patient plaintiffs. So these two, you have the case out of Washington and the case out of New York, basically happening concurrently. And altogether, between Tim's case and Glucksberg's case, you have 15 federal appellate judges who all agreed that there was a federal constitutional right to medical aid in dying. Nevertheless, the two cases were consolidated in 1997. They go to the U.S. Supreme Court, and the U.S. Supreme Court says no, reversing the lower court decision, saying no, there's not a right to medical aid in dying under the U.S. Constitution. So the fact now, if there's no federal constitutional right, the focus then turns back to the states. And so the second pathway that people took was to say, well, if there's not a right under the federal Constitution, maybe there's a right under a state constitution, because some state constitutions grant a broader scope of rights to their citizens than the U.S. Constitution. And we tried that a number of times in at least 15 cases all across the country. Unfortunately, none of that actually worked out. So they didn't work out any better than Tim's case in the end. There was a couple trial court wins, but then those got reversed on appeal. So that happened in New Mexico, it happened in Florida, and it happened in Montana. And then most of the rest of the cases didn't even win at the trial court or the appellate court. There's at least 10 of those cases going back all the way to 1992. The really interesting case involving this computer scientist who wanted to cryogenically freeze his head, but not after he died. He wanted to do it now, before he had a brain cancer, before his disease progressed, which meant basically he was asking for assisted suicide. And the California court said, no, you don't have a right to that under the California Constitution. Similar cases, all rejected state constitutional claims in Colorado, in Alaska, in California, again in California, in Tennessee, and in Hawaii and in New York as well. So the state constitutional route did not meet with success. There's one active case that's happening right now, and that's happening in Massachusetts. So this is a case involved. This is the patient. He's actually himself also a physician, but he is claiming that he has the right to medical aid in dying under the Massachusetts state constitution. And that case was just accepted by the Supreme Judicial Court of Massachusetts, and oral arguments are scheduled for February. But in general, hopefully we'll see how Klagler's case turns out, but generally the state constitutional route has not worked out. So people then turn to what you might call a statutory interpretation route, which is the next pathway that we tried to take to affirmatively legalize medical aid in dying. And here, this is what you might call a definitional approach, where we're trying to say that when a state criminalizes assisted suicide, that doesn't cover aid in dying. Right? In other words, they are two separate things as a matter of definition. And the argument kind of works like this. If you remember the movie, the Christmas movie, where George, It's a Wonderful Life, George Bailey wants to, he's depressed, he's desperate, he wants to jump off the bridge. That's sort of a paradigm of suicide. And the argument is medical aid in dying is very different from that, because it's a considered and reflected upon decision, and the person is already terminally ill. They're already close to death, and they just want to control the precise timing and manner of that death. And so this kind of case was brought several times in Connecticut, in New Mexico, and other states. And the courts actually agreed. They recognized, they said, you're right, we get it. Medical aid in dying is different than paradigm suicide, but at least legally, it's still assisted suicide. So it still is prohibited under the felony assisted suicide statute. The one place where that argument worked out was Montana, because the Montana criminal code is a little different, and it said that the consent of the victim is a defense. And of course, when you have medical aid in dying, you of course do have the consent of the patient. And therefore, medical aid in dying is not illegal in Montana. So that's the one example. Otherwise, the idea of the decisional or definitional approach only worked in Montana. It didn't work anywhere else. So what else have we tried? Well, there's an idea of limiting prosecutorial discretion, right? So here you're not really decriminalizing medical aid in dying, but you're just providing some guidance to patients and providers on exactly how you might do MAID without getting penalized. That was actually the way things worked in the Netherlands before they passed a law. It's the way things still work in Switzerland and in the United Kingdom as a result of this patient's case. And what happened after her case was the Crown Prosecuting Service issued some guidelines, basically a list of factors that said, these are if these factors are met, we probably won't prosecute you. And if these other factors are met, we probably will prosecute you. Well, what that did is it actually gave people in the United Kingdom enough comfort, for example, to accompany somebody to Switzerland where they could obtain medical aid in dying. Without those prosecutorial guidelines, helping them get on the plane, accompanying them to Switzerland would be assisting them in a suicide legally in the United Kingdom. And it still is, except that the prosecuting service says we won't prosecute it. So technically you're still violating the law, but you're going to be okay. We have some examples of this in the United States. Just to give you one, this is in Arizona City, where they passed a resolution saying we urge prosecutorial discretion to deprioritize cases where somebody, for a doctor, helped a patient hasten their death when that patient faced imminent death with intolerable suffering. But that all said, the idea of relying upon prosecutorial discretion is a little risky because you kind of have to trust that the prosecutors will really exercise that discretion. It probably doesn't provide enough comfort to doctors or patients. And then the final pathway, which Tim actually described in his own case, is called jury nullification, where we're not really, again, decriminalizing medical aid in dying, but we're granting what you might call de facto immunity, right? So Tim did violate the law, but the grand jury would not indict. And in fact, same thing in Kevorkian, right? He did violate the law in Michigan, but he was acquitted time after time after time by Michigan juries. Again, that doesn't really provide most people with enough comfort, because you kind of are rolling the dice. You don't know that the jury is going to acquit you. So the way that we really have enacted medical aid in dying in the United States, apart from Montana, is through state statutes. And there's two ways to enact a state statute. You could do it through a ballot initiative, or you can do it through legislation. So in terms of ballot initiatives, all these blue states have a ballot initiative or proposition process. And we tried that in the late 80s and early 90s without success. So we had ballot initiatives to legalize medical aid in dying that didn't get passed. And the problem actually with those ballot initiatives was they were written to legalize both euthanasia and medical aid in dying. Right? So medical aid in dying requires self-ingestion. The patient takes the final overt act. And so it was thought that was the reason those ballot initiatives failed, is because they were going too broad. So in 1994, Oregon puts another ballot initiative up for a vote, and that time it gets passed. Now it ends up in the courts for a few years, and actually they do another ballot initiative for exactly the same thing, and the voters actually pass it again by an even wider margin. So medical aid in dying starts in Oregon, and it has a very solid patient safety record for year after year after year. And based on that, the Oregon model is followed by other states. So in terms of ballot initiatives, followed by Washington, followed by Colorado. And there were some other close calls in Maine and Massachusetts, and some other states have been considering ballot initiatives as well. In terms of legislation, the Oregon model is followed through a legislative approach in Vermont, in California, in Washington, D.C., in Hawaii, in New Jersey, in Maine, and this year in New Mexico. So altogether, we've enacted 3 statutes through initiatives and 3 through bills. So as of today, right, November 9th, 2021, we have 11 jurisdictions where medical aid in dying has been affirmatively authorized, right? And people say that's medical aid in dying is available to 1 in 5 Americans, because they add up the population of those 11 states and divide it by the total U.S. population. And the efforts are ongoing, right? More than half of the remaining states, the other 39, consider bills every session. But and this is where I want to turn now to end up, is the new bills are different than the old bills. There used to be a commercial by Oldsmobile, because I guess they redesigned it, and they said, "This is not your father's Oldsmobile, right? This is new. This is different. This is better." Well, we might say that we adapt that and say, "This is not your father's made bill." But for 25 years, between 1994, when you have the November ballot in Oregon, until 2019, pretty much everything had focused on that original Oregon model from that November ballot, right? And that model was followed in Washington, right? In California, in Colorado. And we might call that MAID 1.0, right? The initial model. But there's a move now, and there has been a move to sort of break that mold, that mold from Oregon, and to focus on access. In other words, looking beyond just making it legal versus instead of being illegal, right? That sort of binary approach. And looking a little bit closer at under what terms and conditions is it available, as opposed to just making it legal or not. In other words, the question is getting asked more, can the patient actually get it? Can they actually get that prescription? And so that's what I want to turn to, and I'm going to call that MAID 2.0 and MAID 3.0. right? So in terms of MAID 2.0, there are a couple developments. One is changing who exactly is a qualified clinician, and second, changing the waiting period. So in terms of qualified clinicians, the traditional rule, the Oregon model, has required that your eligibility, meaning you have capacity, you understand this option, you have a terminal prognosis, right? Your eligibility is confirmed by both an attending and by a consulting physician. But that traditionally has required that both of those clinicians be a physician, meaning that it's an MD or a DO. The problem with that, as we know, is there's a shortage of physicians in many states. So it makes it more difficult by limiting it, the qualified clinicians to physicians. It makes it more difficult to access medical aid in dying. So the response has been to extend the qualified clinicians to nurse practitioners and to physician assistants. It's worth noting for context that almost every state that has pulsed, which is most states, allows them to sign a pulsed order. And so in terms of expanding to APRNs and PAs, that's already happened in New Mexico, and a fair number of states, I didn't list them all, but a fair number of states have bills to do the same thing. In terms of the waiting period, the traditional rule has required a 15-day waiting period. So the patient has to make at least 2 oral requests, and they have to be separated by 15 days. 17 days in Vermont, 20 days in Hawaii. And the idea is to assure that the request is enduring, that the patient has really reflected upon and thought about this carefully, and not acting from impulse. But we know that that length of a waiting period constitutes an undue burden. We now have evidence to demonstrate that. People can't wait that long, right? During that waiting period process, a lot of people are going to lose decision-making capacity or die. So the response has been what? To waive or shorten the waiting period, waive it for at least for the subcategory of patients that can't wait that long, or to shorten it for everybody. We've already done that in 3 states. So Oregon, California, New Mexico have waived or shortened the waiting period, and a fair number of bills in other states seek to do the same thing. So that's MAID 2.0. And then this is my last point. I want to turn to MAID 3.0. And this is what's coming up next. This hasn't happened yet. So this focuses on residency and on the self-administration requirement. So in terms of residency, the traditional rule has been that every state's law says, in addition to be terminally ill and having decision-making capacity, you have to be a resident of that state, right? So the California Innovative Life Option Act is only available to Californians. But there are many, just to take this as an example, if you look where Portland, Oregon is, it's right near the Washington state border, right? So there are people that live on the Washington side of that border who get their health care, because it's the closest hospital or clinic available, they get their health care in Portland, Oregon. And this physician who works at OHSU in Portland, right, has Washington state patients. But he can't, and some of whom would like medical aid in dying, but he can't help them because he's an Oregon doctor. He's in the clinics in Oregon, but the patients are Washington state residents, not Oregon state residents. So he brought a lawsuit just days ago arguing that Oregon can't do this, right? Oregon cannot limit medical aid in dying to Oregonians, which is what the law does. And he says it because it's unconstitutional and it violates what we call the Privileges and Immunities Clause of the U.S. Constitution, which says that the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. So you can't discriminate against non-Oregonians. And then finally, the self-administration requirement. The traditional rule has been that the patient can ask and receive a prescription drug that then they may self-administer to hasten their death. And of course, at least a full third of patients don't even do that. So they may self-administer. And the dominant drug is we now call it DMAPH. But the key point here is that the patient alone is supposed to take that final overt act. There's 3 different ways she could do it. Generally, people would drink it. So you would take the drug and mix it with something like apple juice and drink it, or use a straw. Or you could press a plunger on a feeding tube, or you could press a plunger on a rectal tube. Now, other people, third parties, may help the patient prepare the medication, prepare the rectal tube, prepare the feeding tube, mix it in the cup. But they may not help the patient administer the meds to cause the drugs to go from outside to inside her body. But what about ALS, for example, and some other neurological diseases? In the late stages of something like ALS, the patient is going to be paralyzed in a significant way and may therefore be unable to self-administer, to push the button or to hold the cup or to use a straw. And so the lawsuit in California, brought by some patients with ALS and other neurological diseases, in federal court in California, argues that the End of Life Option Act, to the extent it requires that nobody else can help the patient who needs help, violates the Americans with Disabilities Act because it discriminates against those people who otherwise qualify for the End of Life Option Act, but who just happen to be physically unable to self-administer the medication. So that's what we might call MAID 3.0. So then, as of today, we have 11 jurisdictions that permit medical aid in dying. Next year, in 2022, we're probably going to have some additional jurisdictions, likely Massachusetts, New York, Maryland, or New Hampshire, or maybe all of them. But also, it's not just that there will be more jurisdictions, but that the new laws, the laws of tomorrow, will make medical aid in dying more accessible to terminally ill patients, both in terms of eligibility and in terms of the procedures that they need to follow. Thank you.
Thank you so much, Thaddeus. So let's turn to audience questions. We have ample time to take a deep dive into your questions for our esteemed experts. So please feel free to submit your questions and continue to do so. Kathy is wondering, why don't we use the term assisted death rather than assisted suicide?
We do sometimes. I think the suicide language is very problematic. If you're a philosopher or a if you look at these words technically, I think it's fine because it's accurate. But when you look at the meaning of the word suicide, it usually implies some kind of self-destruction, and that's not what this is about. This is really about self-preservation, not self-destruction. So the word suicide is very problematic, and it's also hard on families as they try to explain this to other people and what they have to do in terms of bereavement. So it's the suicide language is problematic from my point of view.
I don't think that anybody who supports medical aid in dying refers to it as assisted suicide. So the people that would use the term assisted suicide to describe what we're talking about are generally going to be opponents. And frankly, yeah, I don't think it's because it's inaccurate, really, because suicide has such a negative and pejorative connotation, which probably isn't appropriate to cast upon these patients using this option. The reason I used it is because there's a separate statute which might have been written in 1875. It prohibits all assisted suicide, and not this specific end of life option that we're talking about. So I used it because that's what the statutes use. They say you shall not assist another person in their suicide.
Thank you. Mark is wondering, Disability rights groups oppose this legislation, saying that it is an opportunity to force suicide on disabled patients. What might the response be to ameliorate their concerns?
Well, I mean, first of all, the disabilities community is way more diverse than you would think, listening to the political speak from the disabilities community as if it's monolithic. It's very diverse, and there's tremendous support among many people within the disabilities community for this possibility. It's very hard to counteract that. But the best way to protect the disabilities community is through enacting safeguards that include good second opinions, a mental health evaluation for anybody who's considering this, who might be in a vulnerable situation. So I think the safeguards are the best protection for people with disabilities, and many of whom would want to have this possibility. In disability, the same thing applies, by the way, to stopping a life support. That within the disabilities community is actually a much bigger question, because many more people are dependent on life-sustaining therapies, which they have the right to stop. Again, we want to make damn sure they're sure before they do that. So that's the same kind of safeguards. That open processes, second opinions, really excellent documentation are the best protection from my point of view.
Yeah, I'll just add that there's no evidence that anyone has been, I think you used the word forced to use medical aid in dying, right? So Oregon started in 1998, right? That's 24 years, plus, 14 years in Washington, 6 years in California, right? In all these years of using medical and dying in all these states, there's not a case of any coercion or duress. And in fact, the federally designated disability rights organizations in each state themselves have issued reports saying we haven't found any problems with respect to the disabled being coerced into using this. So it's a pretty long and well-documented track record.
Absolutely, thank you. Judith is wondering, will dementias ever be considered as terminal diseases so that MAID can be available to those patients?
Well, there's certainly discussion about this. I think many people would like to have that as a possibility, and but it's hugely problematic in the sense that many people want this option, but they're not going to choose it until they really need it. And then when you really need it, when you have dementia, you no longer have capacity. And we know that a lot more people think about this than actually activate it. So I think it's very tricky terrain to do. This is where I think comfort, very aggressive comfort care should be standard of care for people who want this option, who are wanting not to die before they get dementia, but want to wait till they get into it to go. And I think asking others then to make the timing decision is a lot just practically, it's a lot to ask. And so I think comfort feeding only, and in particular minimal comfort feeding only. So the least, if I have dementia, the least amount of food that I need just for comfort is really what I want, and no other treatments. I think that's probably going to be our default position, at least the one that's going to cover most of the cases.
Yeah, I think it's going to be a while. Maybe it's worth separating. There's two ways that it might happen, right? Is you act preemptively, right? So you have your relatively early stage dementia, and the idea is we would change the law to allow you to qualify for medical and dying now. So we're going to require the capacity requirement that you have to self-ingest and that you have to do it with capacity. The problem with that, of course, you're going to have to hasten your death way earlier than you might otherwise want. So that would require taking that 6-month prognosis out and saying, as long as it's a progressive incurable illness, right? The other way to go would, as Tim suggested, which is you don't want the medical aid in dying until later on. The problem is you may not have capacity later on. So that pathway would require that we allow advance requests for medical aid in dying, which is super complicated. And Canada's working on that now. The Netherlands is still kind of ironing out they allow it, but they're still trying to iron out the protocols because hardly anybody uses that option. The doctors aren't really comfortable with it. So we're not leaders on this, right? Canada has way broader scope of availability of MAID than the US. The Netherlands has a way broader scope. And so at least on the dementia question, in a sense, they might pave the path and iron out some of the ethical issues and iron out some of the logistical issues. And then once they pave the path forward, some US jurisdictions might then follow. But they haven't even figured it out yet. So we're probably not, that's not imminent for US.
And that's probably an extreme understatement. It's, because it's going to be really, it is fraught with both ethical and practical problems, even under the best of circumstances. And it doesn't mean it can't be done, but boy, you'd really have to figure out, how do you consent people to that? And how do you know when somebody's consented, when they have capacity, that it's time? Because those things are very hard for families to figure out, and clinicians to figure out. And again, the patient's not going to be able to help you at that point. So it's a long way off, I think, as it probably should be.
Absolutely, change takes time. Thank you. So Lewis in the chat is wondering, will MAID 4.0 follow Canada and Europe's lead and go beyond terminal prognosis and alternately be based on irreparable suffering? What will it take for us to achieve this? And this is and under the umbrella of what does it mean to achieve full options for a completed life within the US, but looking towards Canada and Europe's lead. What are your thoughts?
Yeah, I agree that I mean, I hate to create a whole bunch of new vocabulary, but that probably would be MAID 4.0 because the terminal illness requirement has been thought to be one of the central elements. So to change the idea of residency, I don't think was thought to be really central, right? So if we change the residency and allow non-Californians to get California MAID, I don't think that's a core essential nature of what we thought was a core safeguard. But the terminal illness, I think, is thought to be more central. So yeah, first of all, I agree that that might be properly described as MAID 4.0. And I do think that we will go there. The U.S. is, again, you can look around the world, right, to Spain or Canada or Australia or New Zealand, right? And that many of now at least the Australians are similar in requiring a 6-month prognosis, but even they will allow it to go to 12 months for some types of diseases, right? So we are really restrictive when you match us up against other jurisdictions around the world. And so again, I think it helps, right, that other people create a track record. Canada has a very solid patient safety track record with medical aid in dying. And so I think that will, again, they'll pave the way for us. So I do think we will reconsider that 6-month requirement.
I do think that stopping eating and drinking is going to be an interim option for folks, because that does not require the terminal prognosis. And again, it also has the safeguard of being, it's entirely in the patient's control, right? That's the patient's thing. They got to do it or not do it. It's a little hard to do. And that's not necessarily a bad thing as you're getting out to things that are further out on the horizon. So that, at least as of right now, would be the one option that people do have who are in that kind of circumstance, who really want to do it. Now, it may not be what they want as an option, probably isn't, but it is there. And and it does have a certain level of a little bit stronger extra safety.
Thank you. And for those wondering, both Dr. Quill and Professor Pope are co-authors on the recently published book of the same name, Voluntarily Stopping Eating and Drinking, published by Oxford University Press earlier this year. I'll put the link to the book in the chat. And just as reference, we hosted 2 events about this excellent book back in October of this year. So if you haven't yet, please take a look at the recording after this event. So thank you. So Ron is wondering if mental capacity is required to make a valid future advance directive, why is the same not required for making a valid will? Your thoughts?
I don't know that I agree with the premise. I think you need capacity to complete a will or an advance directive. It's typically not tested. In other words, everybody's presumed to have capacity. But when you sign either of those types of planning documents, you should have decision-making capacity at the time that you complete either of them.
Yeah, if you signed a will that was completely changing the way you had thought about things for your entire life, and that will would be challenged in all likelihood, particularly if it was taking all of your stuff in a completely different direction. So it doesn't mean that you can't do it, but I think these are things that do require some analysis to make sure that they're really reflecting, and what they're supposed to reflect is what you really want, right?
Well, I mean, so I know I could give you cases where somebody left out a kid, right? So there's a lot of money at stake, and somebody didn't get anything. They attacked the will, and a key ground on which they attacked the will is to say, well, mom didn't have capacity, right? So the will's invalid. And in fact, it is important if you're afraid that your will might be challenged on the ground that you didn't have capacity at the time that you completed, or if you're afraid your advance directive might be challenged later on the grounds that you didn't have capacity at the time you completed it, you can document the fact that you had capacity at the time you completed it. You could have a psychiatrist or mental health professional affirm that, right? The normal way advance directives are just witnessed or notarized, but of course, lay witnesses or a notary don't really have the capacity, don't know how to assess capacity. It also helps to actually, and we recommend this in our book, to create a video to supplement the will, or a video to supplement the advance directive. Because if we can see Tim talking, we think, well, he seems pretty coherent. And it helps give people more comfort than just the document itself, that the person really meant it and they really understood what they were talking about.
And if there are elements of your advance directive or your directive that you think people will find surprising, then those are the elements that you want to put in some extra narrative to explain, maybe have somebody else verify and talk to them about it, so that you really, because if that's what you want, it's good to put that out there and get it as clear as you can. But if it's going to be a surprise, then do double diligence, making sure it's well documented, that it's what you really want, why you want it, is as clear as you can make it.
Absolutely. And Ron had a follow-up comment. He said, a will executed decades ago is honored, but not so with advance directives.
I don't know that
That's true. I mean, most states' advance directives don't have expiration dates. So it's legally valid. I mean, but although the difference is, I think many times people think, I wonder if she really, people start to question it, right? I mean, so the recommended best practice is to update your advance directives whenever you have any of the 5 Ds, right? Every new decade, if there's a death of a spouse, you get a new diagnosis. If you have a divorce, if you move to a new domicile, like from a house to a nursing home. So any of the 5 Ds should trigger a new advance directive, because we want to have confidence that what's written there represents, your preferences for you right now today. And if it's that old, but legally it's still valid. It's just that we do doubt that it represents your current preferences.
Thank you. Ariel has written, she's in graduate school. She wrote a paper in which she argued that physician-assisted death was morally better than palliative sedation. And she's wondering if either of you have thoughts on the issue.
Well, I have some thoughts about this issue, and that is that physician-assisted death is a definitive event, right? You know something happened, and you want to make sure the circumstances around it, the decision leading up to it, all that is well documented, and there's not a lot of ambiguity that it's there as an event. Palliative sedation is all over the place. If you take a look, for example, within palliative care programs in the hospital who care for terminally ill patients, and home care programs for that matter, the percentage of people who die heavily sedated varies tremendously between programs. And that, in my opinion, probably does not have, it has probably more to do with the clinician's views and values than the patient and family's views and values. So I think, there's a lot of desire to make sure the patients and families are driving sedation, or at least aware of what's going on and why it's going on. And I think there's a lot more variation in that zone than there is in assisted dying.
I mean, I think what Ariel, right, is suggesting is that palliative sedation to unconsciousness, a particular form of palliative sedation, is almost always linked to a decision to withhold artificial nutrition hydration. So it will lead to the patient's death from the patient's dehydration, right? So you have two permissible acts, palliative sedation, and you have a well-grounded, well-established, decades-old right to refuse artificial nutrition hydration. You sort of combine those two things together, and you actively hasten your death. I don't see them, I mean, from a completely moral or ethical perspective, I don't see one as more I see them, I mean, they're both legitimate options, but I agree with Tim that and we just wrote this book on VSED because VSED was sort of under discussed, under examined. And as Tim suggests, I think that PSU, palliative sedation and consciousness, is even more under-examined than VSED, right? So I think we need to reduce that variability and produce better clinical practice guidelines and policy statements on that.
We in our palliative care program in the hospital, we developed clinical criteria for sedation to unconsciousness because it's first of all, it's very close to euthanasia. You know, if you sedate somebody to unconsciousness and you don't give them fluids, 100% of people will die. So it is a life-ending event that doesn't necessarily make it wrong, but it's a big event. And if you're going to allow that, which sometimes you have to because there are sometimes very tough symptoms at the end of life, it's really good to document what you're doing and get second opinions. So somebody else looks in and says and can verify this is what we're doing, and this is why we're doing it, and that's both for the patient's and family's protection, but it's also for the clinician's protection because you could get second guessed on this, and it looks a lot like euthanasia, slow euthanasia, where there's tremendous variation between palliative care programs and how frequently they go to this, and that has to do with programs. It has more to do with programs than patients, unfortunately.
Perhaps that's the next book after VSED on palliative sedation. So for those who are interested, you can purchase a copy of the VSED book. I put in the link to Amazon in the chat. Kathy's wondering, Thaddeus, would you mind reviewing the 5 Ds briefly again? And I will put them in the chat as well.
Yeah, they're pretty commonly repeated. So they're not my 5 Ds. They've been around for a while. I'm not sure who coined them, but right? And it's just a benchmark, right? I mean, but every new decade, right? So you turn 70, you turn 80. So a decade diagnosis. So you get a new diagnosis with a new illness. Divorce. And the reason for that is because advanced directives have two parts, right? There's a part where you identify your healthcare preferences, and then there's a part where you identify the agent who will speak for you. Since the agent is typically a spouse, if you get a divorce, you may want to reconsider who you're appointing as your healthcare agent. Domicile, right? So if you change where you know, particularly if you move into from your own house to some kind of long-term care setting, that's a reason. And am I forgetting one? Did I say 5? Death, divorce, diagnosis, domicile, decade. Is that 5? Okay.
Yep.
Yeah.
Yep.
But anytime, you know, you should, I mean, it's worth, you know, reconsidering it every few years.
And reading
Thank
it.
you. And I put the 5 Ds in the chat as well.
Yeah, I mean, the other thing is what happens, unfortunately, a lot is that the agents do need to be updated. So the divorce trigger is, I guess, important, but it's under-inclusive because you may outlive or outage your agent, right? So if you're appointing if you're an older person, right, and you're appointing your spouse or your sister or somebody to be your agent, well, they're also all in their 80s, right? So there's a chance that they either may have died before you, or they may lack capacity because people do have capacity issues as they age. So you have to check whether your agents are still available, and you may need to identify new agents.
And just going back to 101 in advanced care planning, probably one of the more common errors is to name somebody and then not have an in-depth conversation with them about your preferences. So they are lost, or they're going to they're going to manage the end of your life according to their values. That might be okay with you, but the job is really to try to manage them using your values, and they have to know your values. And that takes some serious conversation about what you want, what you don't want, what kind of deaths you've seen in your family, all that stuff that people, if you're going to be an agent for somebody, that's a serious responsibility, and it requires some real homework to be done.
So one element of aid in dying is filling the prescription for the patient to self-administer. And I was wondering if you could touch upon the element of pharmacy availability of supplying these medications, and how that landscape has changed over time since the early 90s, mid 90s rather, till now, and whether access, this came up at session 1 last Thursday as well, of barriers to access on the ground in terms of whether you have a primary care physician who is willing to refer you to, you know, get your medication filled at the local pharmacy, and perhaps there's only one in the state, and how do you go about navigating those barriers. So I was wondering if you could give us an overview on how it's changed, and perhaps where it could go from here.
Well, first of all, I think that this is a great question to ask or to explore when Dr. Shavelson speaks, because he perhaps is one of the top experts who thinks about the pharmacology of medical aid in dying. But just as a non-expert on this specific issue, for a long time, from the 90s to the early 2000s, people used ticobarbital, which is a prescription drug, right? So it's manufactured by a pharmaceutical company, and it was reasonably available. Then more recently, it's not available, and it's almost never used anymore. And so now what's used is a compounded drug. And so I mean, maybe this is what the question is getting at. One consequence of that is you can't just get it at any pharmacy. It has to be a compounding pharmacy. And there are far, far fewer compounding pharmacies than there are regular pharmacies. So it does make it arguably more, it definitely limits the available options from which to get it.
And of the compounding pharmacies, not all of them will compound this particular concoction. So it not only they have to be a compounding pharmacy, but they have to be willing to do this. So in the areas where this is legally available, you know, that's a path that's got to be well sorted out, because you can spend a lot of energy going to the wrong places, getting rejection, you know, having all kinds of people weigh in on what you're trying to accomplish. So this is a part of this process that is quite problematic at present.
Yeah, I mean, the flip side is that in any state, not that many people actually use this option, right? So it's like 100, 200 in a whole state in a whole year. And so it's not like one pharmacy can handle it, right? If it's willing to participate, so that would be sufficient. So I didn't want to suggest that we don't have the capacity to meet the demand. But as Tim suggested, you do need to know where to go.
Absolutely. Thank you. Well, a follow-up question from Kathy. She's wondering, will pharmacies mail the drugs? Is this a possibility?
I'm going to say I don't know, but if mailing drugs like this is any precedent, they're not going to mail it. I think it would be, it's like, these are serious drugs, and you would not want those to be hanging around in your mailbox. You know, I mean, I suppose you could do it, have a FedEx delivery or something like that, where you knew it was going to be delivered to your doorstep and have to be signed for. That would be the kind of thing that you'd want to have if you were going to do it that way. And so in a rural area, that's what you'd probably have to do.
Yeah, I'm not. That's a good question. I'm not sure, but I agree that you could use. I don't know if you could use Uber or one of those type of delivery services. Yeah, that's another good question. Is it Thursday? That's another good question on the nitty gritty granular details.
Curious minds want to know. So on Thursday, and I will give a shout out to our session coming up this coming Thursday about featuring Lonnie Shavelson and Tracy Bush, both clinicians and providers in California, and they'll be able to help answer some of these more direct questions. And I'll put up a flyer for that at the end of our session today. And so a follow-up question related to accessibility issues, but touching upon the issue of telehealth. You know, the COVID-19 pandemic has really pushed providers and organizations to pivot to the online sphere. And now that we're in this new normal of COVID adjusted times with more of a hybrid atmosphere, telehealth has come more to the forefront, and wondering whether and how telehealth has been implemented, and to what degree that's been implemented regarding aid in dying consultations. What are your thoughts?
It has been implemented widely. So the American Clinicians Academy on Medical Aid in Dying, ACA MAID, which is the expert professional society for clinicians that participate with MAID, issued a guidance statement on how to do telehealth. Compassionate Choices also issued some guidance, and it's worth noting that even in Canada, generally telehealth was used during the pandemic for medical aid and dying there as well. So, and that could be for the initial request. It could be due for the assessment for whether the patient is even eligible for the second request. So yes, it's the COVID-19 pandemic definitely accelerated the use of telehealth for medical aid and dying.
Thank you. Let's see what my chat.
I mean, there are
Oh,
obviously
go
limits, right? I
ahead.
mean, if there's not already a diagnosis in the record, you know, you may need, you know, then you may, if it depends on the patient, right? It depends. You may need to do an in-person physical exam to determine their prognosis. So you know, but it's generally available. It's just that there may be some specific patient situations where telehealth is not going to provide the right kind of diagnostic, you know, evidence base that you need to make the determinations that you need to make.
So as a follow-up, how either limited or extensively is telehealth being used throughout the U.S. To make these assessments or provisions? I believe Hawaii has been mentioned. Are there other states as well?
Yeah, I mean, no, I mean, I think you can use it. It gets complicated because it depends on whether or not sometimes you already had an existing physician-patient relationship. So some states say you can use telehealth, but not to form the relationship, but once you already have the relationship. So then it depends. Are they coming to you for the first time through telehealth, or were they already your patient and now you're having a telehealth visit about a specific thing with an existing patient? But generally, I think it's been used for at least some, in perhaps in some cases, all aspects, all visits related to medical aid in dying. So it may vary from state to state to state, from situation to situation to situation. But Hawaii, I think what Hawaii said was you could do it for the mental health. So Hawaii is unique. Every state says you only need an attending and a consulting. Hawaii says no, you need to have 3 visits. Everybody needs 3 visits. You need to have a mental health visit for everybody. While every other state said, well, you only need to have that 3rd mental health visit if either of one of the first 2 physicians thinks you might have a decisional impairment. If they think you're good, we don't need to have a 3rd mental health visit. So Hawaii requires that 3rd one, but then they said, well, for that 3rd one, that can be through telehealth. So it was sort of a way to mitigate some of the onerous or burdens of making yet a 3rd clinician assessment. Is to say, oh, okay, we're going to require that 3rd clinician assessment, but it can be through telehealth to soften that requirement a little bit. But even if the other states don't affirmatively address telehealth and medical aid in dying, it's still permitted under just general telehealth rules of practice.
These decisions are also being made all the time around stopping life supports as well. So there's a lot more, you know, the number of cases that are actually assisted dying cases is small, but the number that revolve around stopping of life-sustaining therapy or stopping of treatment that may end up in death, I think those decisions are done quite regularly, and the adaptation to telehealth is really pretty broad, so that people are used to making pretty complex decisions with telehealth. Now, again, the more the decision gets gray in either domain, so it's not quite clear whether they have capacity, it's not quite clear what the illness is, it's not quite clear whether there's mental health issues that are confounding the decision. That's where telehealth would not be sufficient to make a decision of this magnitude. You'd really want, you know, second opinions, face-to-face visits, because this is not simple terrain at all.
Absolutely. To the point about mental health considerations, the next question relates to Canada's aid in dying law, allowing for mental health provision in a couple of years from now. Can you offer a comparison between the proposed stipulation in the Canada law coming up soon, in the next couple of years, with the current laws rather in the
So I haven't refreshed myself on Canada, but so in March, this March of 2021, C7 put a 2-year bar, right? So I don't know that they said we affirmatively are going to allow mental health you to qualify on the basis, qualify for medical aid in dying on the basis of a mental health illness in 2 years. What I recall was the language said, definitely can't do it for 2 years. So it was a freeze or a hold, because I think the understanding is we need 2 years to figure out, are we going to do it? And if so, under what conditions and what are the safeguards? I think those are being worked out now. So I don't know that it's a foregone conclusion that in March of 2023, there will be, you can qualify for medical aid in dying in Canada on the basis of a mental illness. What is allowed in Canada right now, in this, going back to some of the earlier questions, is dementia is not considered a mental illness. So people with dementia in Canada can and do now qualify for medical aid in dying. So that's not part of the hold. That's not part of the 2-year hold.
It's hard to overestimate how difficult it is to make such a decision of this magnitude for somebody with serious mental illness, and the number of clinicians who have enough experience to assess such patients is small, and then you need somebody to do a second opinion, and this is very, very unique, sophisticated work, and just to say that the fact that there is that much hesitation is not necessarily a bad thing, even though that leaves a lot of people who are in that zone a bit on the lurch for a longer period of time. So there is a downside to procrastination, but this is really very tricky terrain, and one where you'd really want to have numerous second opinions by people who are really experienced in the zone that patient is in.
Thank you both. And one last question from Joelle. She's wondering, perhaps aside from VSED and medical aid in dying, are there other paths or written sources that can help a person describe what they would like in achieving a peaceful, painless death at the time of their own choosing?
I'm not sure that I quite caught the question, so see if we can say it again.
Sure thing. She's wondering, aside from voluntarily stopping eating and drinking and aid in dying, are there other paths or written sources, perhaps aids or advanced directives or other resources? In past events, we've mentioned the SED by AD. And so she's wondering, how can we really empower individuals to articulate how they want their own peaceful, painless death to occur and at the time of their own choosing. So perhaps a way, you've mentioned taking a video advance directive of the patient verbally articulating their wishes, but really to what would be your thoughts a little bit further on this question?
Well, I think Tim had a slide which listed, basically all of the key end of life options, right? So everything from in order of like social acceptability. So I think that the only thing, if you go back to that, look at that slide, the only thing that's not on that slide is something Tim later mentioned in a separate slide, which is non-medical options. So everything Tim identified in terms of his exit options or end of life options were medically supervised options. And so the Final Exit Network and the Hemlock Society of San Diego and some others have a focus, not an exclusive focus, but they definitely focus on non-medical options, and provide guidance for people who want to hasten their death, but without the help of a physician or a clinician. So those two organizations, I think, have resources that, as Tim said, it's often referred to as self-deliverance. And they have a different, sometimes it's using inert gases, and a couple other methods like that, which are described in the book that Tim talked about. They're described in Derek Humphrey's book.
I think for people who are interested in what the full range of options are, I think there is we have there's a couple of references, I think, in the list of references for this talk that just have a listing of the common medical options, and I think that's familiarizing oneself with those options is a good idea, and kind of thinking about how they would fit different circumstances, and then these non-medical options, again, that you're going off on a different level of out there on your own with that. The medical options at least have a medical assessment as a piece of it that can be good or not good depending on your point of view. But that's a safeguard in them, whereas the other options don't have those kinds of safeguards. And again, probably if you're looking at all the options, probably worth familiarizing yourself with. But yeah.
Thank you both so much. So I'd like to invite your final concluding comments. Today's presentation has been fascinating and enlightening, and I want to thank you both so much. But as a takeaway point for our audience, what would the highlights be for each of you? So let's start with Tim and then over to Thaddeus.
What would be my takeaway points? I would say number one, if you are looking at these kinds of things and you have a serious illness, find yourself a good, trustworthy medical partner who's got an open mind and who'll look at all the options with you, because it's really important to have a medical partner that you can look at the full range of possibilities, because the majority of people who look at these things like to know there are possibilities that they actually never need, because palliative care and hospice works most of the time. So reassurance that there could be an option that you don't need, but then if you do need them, you need a medical partner by and large to help you access them or figure out what they are. I think talking to people who talking to people who have a lot of experience, if you can find them in this zone, would be very helpful, particularly if you're beginning to take it to look at the serious possibility for yourself, and then making sure your family's all on board, because they also have to. They're also left picking up the pieces afterwards, having to make sense out of this afterwards, and that's a serious thing. So if you're not involving them, that's a major decision that really ought to be thought through and maybe explored with a good friend, because those people are going to be left wondering what the hell happened and I should have done something, and that's very problematic. So yeah, but looking at the full range of options, I think is probably the key, and making sure that you're getting good palliative care and hospice, because that still remains the standard of care.
Thank you, Tim. And Thaddeus.
Yeah, I'll just say that we've been talking mostly in this talks about medical aid in dying, which is used in the U.S. by less than 0.5% of all the people that die in those states. So I think my biggest takeaway would be, let's look at the other 99% of people who die every year. Many of them don't die in the way that they want. And I think a key way to avoiding treatment that you don't want and getting treatment that you do want is to engage in careful advanced care planning. And I think it's, it may require more than just, one Saturday morning. You may want to go through several different of the tools, the planning tools. And so I think that's probably the single biggest thing is medical. Most of us are never going to use medical aid in dying. But most of us are going to lose capacity at the end of life, and we're going to rely upon others. And so if we want to make sure that our preferences are known and our preferences are honored, careful advanced care planning, really important.
Excellent. Thank you so much, Thaddeus and Tim. It's been an honor to sit here with you today virtually via Cisco WebEx. I just want to offer a round of applause to both of you, since our audience is hidden behind the invisible curtain of our event today. But thank you all so much for being here, for asking your questions. We were grateful to include them and be able to facilitate a deep dive into what you're curious about with Thaddeus and Tim today. So thank you so much for showing up, and a round of applause again to both of you. And thank you again for tuning into the second annual Completed Life Fall Conference. This was session 2. We have 2 more sessions coming up for you. The next session will be this coming Thursday, November 11th. Same time, same place, via Cisco WebEx from 12 to 2 p.m. Eastern. And session 3 will focus on is the right to die being held hostage to a right to health care? So an interesting topic, interesting title, and it will dive into unwanted care and care that is not well considered at the end of life. So we look forward to welcoming esteemed colleagues and friends of the Completed Life Initiative, Dr. Lonnie Shavelson and Tracy Bush, for what will surely be a fascinating conversation that will continue on the thread of today's presentation, looking at barriers to access for diverse communities. So thank you again so much for being here. Please take care, and we look forward to seeing you next time in session 3. Be well.